Bismillahirrahmanirrahim. Assalamu alaikum. Welcome to MCQ series of Judicial Exam Preparation. अच्छा जी, आज का जो सब्जेक्ट है वो है गार्डियन एंड वार्ड एक्ट। जैसे कि आपको जो पता होगा कि सिलेबस के अंदर जो है वो गार्डियन एंड वार्ड एक्ट विद रेलिवेंट प्रोविजन ऑफ हाई कोर्ट रूल अंडर लिखा हुआ है। तो मैंने इसमें MCQs बनाए हैं सबके। तो वो हाई कोर्ट रूल एंड ऑर्डर वॉल्यूम 2 चैप्टर 2 गार्डियन एंड वार्ड से रिलेट करते हैं, उसके भी MCQs इसी के अंदर है। कोशिश करूंगी कि इसी वीडियो के अंदर वो भी हो जाए। अगर नहीं हो सके तो फिर उनके लिए एक अलग वीडियो बना दूंगी। चलो जी, शुरू करते हैं। बिस्मिल्लाहिर्रहमानिर्रहीम। व्हाट इज द शॉर्ट टाइटल ऑफ द एक्ट अकॉर्डिंग टू द प्रोवाइडेड टेक्स्ट? आंसर है इसका द गार्डियन एंड वार्ड एक्ट 1890। अगला क्वेश्चन है जी, टू विच जियोग्राफिकल एरिया डज द गार्डियन एंड वार्ड एक्ट 1890 एक्सटेंड अकॉर्डिंग टू द टेक्स्ट? द होल ऑफ पाकिस्तान। नेक्स्ट है जी, ऑन व्हाट डेट द गार्डियन एंड वार्ड एक्ट 1890 कम इनटू फोर्स? आंसर है इसका 1 जुलाई 1890। आगे जी, व्हाट हैपेंड टू सेक्शन 2 ऑफ द गार्डियन एंड वार्ड एक्ट 1890? इट वाज रिपील्ड बाय द रिपीलिंग एक्ट 1938। नेक्स्ट, अकॉर्डिंग टू सेक्शन 3 ऑफ द एक्ट, हाउ शुड द Guardians and Ward Act 1890 be read in relation to enactments concerning courts of wards? Answer is that it should be read to subject to every enactment related to any court of wards. Next, what is the definition of minor provided in section 4 subclass 1 of the Guardian and Ward Act? A person deemed to not to have attained majority under the Majority Act 1875. According to the Act, what does the term guardian refer to? Answer is C. A person having the care of the minor's person, property, or both. Next question is, what is the definition of the ward as per this act? Answer is a minor for whom a guardian has been appointed or declared concerning their person or property, or both. Next is, how is the district defined within the context of this act? Answer is C. It has the meaning assigned to it the Court of Criminal Civil Procedure 1908 and includes the High Court in its ordinary original civil jurisdiction. Again, according to section 4 subclass 5 subclass A, which court has the jurisdiction to entertain an initial application for the appointment or declaration of the guardian? Answer is that the district court having jurisdiction to entertain such an application. Again, according to section 4 subclass 5 subclass B subclass 1 and 2, once a guardian has been appointed or declared, which court is considered the court for subsequent matters related to the guardianship? Next, answer is the court that ordinarily appointed or declared the guardian, or the court of the officer who did so or is deemed to have done so. Again, in matters relating to specifically to the person of the ward, which district court is considered the court according to section 4 subclass 5 subclass C? Option is the district court where guardian resides, the district court where the ward was born, the district court having jurisdiction in the place where the ward for the time being ordinarily relies. ये इसका आंसर। अगर रॉन्ग है तो आप कमेंट सेक्शन में राइट आंसर जरूर बताएं। अगला क्वेश्चन है रिगार्डिंग प्रोसीडिंग ट्रांसफर्ड अंडर सेक्शन 4 4A, which court is considered the court according to section 4 subclass 5 or subclass 6? The court of the officer to whom such proceeding has been transferred. Next question is, according to the act, who is considered the collector? Answer is the chief officer in charge of the revenue administration of a district. Again, beside the chief officer in charge of revenue administration, who else can be appointed as collector under this act? Answer is any officer whom the provincial government by notification in the official gazette may appoint by name or by virtue of their office for specific purpose or areas. Next, what does the term prescribe mean within the context of this act? Prescribed by rules made by the High Court under this act. ये जो मैंने अभी बताया वॉल्यूम 2 और चैप्टर 2 में, वो इसी के अंदर उसके भी MCQs हैं। Next, where would one typically find the details of matters that are prescribed under the Guardian and Ward Act 1890? Answer is C. In rules formulated and issued by the High Court under the authority of this Act. Again, what is the role of the provincial government in relation to the definition of collector under this Act? Answer is the provincial government can through official notification appoint additional officers as collector for specific areas, persons or purposes of the Act. आगे है अकॉर्डिंग टू सबसेक्शन 1 which authority has the power to empower unsubordinate judicial officers exercising original civil jurisdiction to dispose of proceedings under this act. High Court. Next is what kind of order can the High Court issue to empower subordinate judicial officer? Answer is either a general or special order. Next is besides the High Court, who else is authorized to empower subordinate judicial officer to dispose of proceeding under this act according to subsection 1? Answer is the judge of any district court with respect to officers subordinate to them if authorized by the High Court. आगे है जी अंडर व्हाट कंडीशन कैन अ डिस्ट्रिक्ट कोर्ट judge empower a subordinate judicial officer? Answer is if the High Court has authorized the district court judge to do so. Again, according to subsection 2, who has the authority to transfer proceeding under this act that are pending in their court to subordinate officer? Answer is the judge of a district court. Next is at what stage can a district court judge transfer a proceeding under this act to a subordinate officer? Answer is at any stage of the proceeding. Next is to which type of subordinate officer can a district court judge transfer proceeding under this act? Answer is to any officer subordinate to them who has been empowered under subsection 1. आगे है जी what form must the district court judge order for transferring a proceeding take? It must be a written order. Next is according to subsection 3, what power does a district court judge have regarding proceedings pending in the court of a subordinate officer? The answer has the power to transfer the proceeding to their own court or to another empowered subordinate officer at any stage. Next is to whom can a district court transfer a proceeding pending in the court of another subordinate officer? To their own court or to any officer subordinate to them who is empowered under subsection 1. Again, according to subsection 4, under what circumstances can a district court judge declare that the transferee court will be deemed the court that appointed or declared the guardian? Answer is when any proceedings are transferred under this section in a case where a guardian has already been appointed or declared. Next is what form must the district court judge declaration take regarding the transferee court being deemed the appointing court? Answer it must be a written order. Again, for what purposes can the district court declare the transferee court to be the court that appointed or declared the guardian? For all or any of the purposes of this act. Again, which court has the ultimate authority to empower subordinate judicial officers to handle proceeding under this act? Answer is the High Court. अगला क्वेश्चन है जी अकॉर्डिंग टू सेक्शन 6 व्हाट डज दिस एक्ट नॉट टेक अवे और डेरोगेट फ्रॉम इन द केस ऑफ अ माइनर हु इज नॉट एन यूरोपियन ब्रिटिश सब्जेक्ट? आंसर is any power to appoint a guardian of their person or property or both that is valid under the law to which the minor is subject. Again, in the context of section 6, what is the significance of phrase law to which the minor is subject? It acknowledges the validity of guardianship appointments made under the minor's personal law or religious customs. Again, under what condition can the court make an order appointing or declaring a guardian for a minor according to section 7 of clause 1 if the court is satisfied that it is for the welfare of the minor? Sorry. ये तो इस एक्ट की सबसे फेवरेट स्टेटमेंट है ना, वेलफेयर ऑफ द माइनर. अगर आपको एमसीक्यू में कोई ऑप्शन ठीक ना लग रहा हो लेकिन वहां पर वेलफेयर ऑफ द माइनर लिखा हो तो वो टिक कर दीजिएगा. Again, according to section 7 of class 2, what is the implication of a court order appointing or declaring guardian under this section? It implies the removal of any guardian not appointed by will, other instrument or by the court itself. Next, according to section 7 of clause 3, when can the court appoint or declare another person as guardian in place of existing guardian who was appointed by will, other instrument or by the court? Only after the power of the existing guardian have ceased under the provision of this act. What is the primary consideration for the court when making an order regarding guardianship under section 7 of clause 1? Answer is the welfare of the minor. Next, which of the following types of guardian is not automatically removed by a court order under section 7? A guardian appointed by will. Will के जरिए जो भी guardian appoint होगा वो remove नहीं किया जा सकता आसानी से. According to section 8, who is entitled to apply for a court order appointing or declaring a guardian for a minor, the person desirous of being or claiming to be the guardian, any relative, any friend of the minor, or the collector in certain circumstances. Which of the following individuals is or entities is specifically mentioned in section 8 as being entitled to apply for a guardianship order? The collector of the district where the minor ordinarily resides. Next, according to section 8 subclause D, under what condition can the collector apply for a guardianship order? Answer is if the collector has authority with respect to the class to which the minor belongs. Next, according to section 9 subclause 1, to which court should an application for the guardianship of the person of a minor be made? Answer is the district court having jurisdiction in the place where the minor ordinarily resides. Next, what is the determining factor for jurisdiction of the district court when the application relates to the guardianship of person of the minor? Answer is the place where the minor ordinarily resides. Next, can a relative or friend of the minor apply for a guardianship order even if they do not desire to be the guardian themselves? Answer is no. Only those claiming to be the guardian can apply. Again, in which of the following scenarios would the collector of a district like have the authority to apply for a guardianship order under the section 8 subclass D? Answer is when the minor's property is located within the collector's district. Next, according to section 9 subclass 2, to which district courts can an application for the guardianship of minor's property be made? Either to the district court where the minor ordinarily resides or to the district court where the minor has property. Again, what are the potential bases for jurisdiction when an application concerns the guardianship of a minor's property? Answer is the minor's ordinary residence on or the location of any of the minor's property. Next, according to the section 9 subclass 3, under what circumstances can a district court return an application made for the guardianship of a minor's property? Answer is if the court believes that another district court with jurisdiction could dispose of the application more justly or conveniently. Again, what is the primary consideration for a district court when deciding whether to retain or return an application for the guardianship of minor's property filed in a court other than the one where the minor ordinarily resides? Which court can dispose of application more justly or conveniently? Next, if a minor ordinarily resides in Lahore but owns property in Karachi, in which district courts can an application for the guardianship of their property be filed either in the district court of Lahore or the district court of Karachi? Again, next question, if an application for the guardianship of property is filed at district court of Multan where the minor has some property but ordinarily resides in Faisalabad, can the Multan court return the application? Yes, if the court believes that the Faisalabad district court could handle the matter more justly or conveniently. Again, what is the implication of section 9 subclass 3 regarding the choice of forum for property guardianship applications when the minor resides in one district and has property in another district? Answer is the court where the application is filed has the discretion to decide if it was the most appropriate forum. Again, according to section 10 subclass 1, if the application for guardianship is not made by the collector, what forum must it take? A petition signed and verified in the manner prescribed by the Code of Civil Procedure 1908 for the signing and verification of a plaint. Again, when an application for guardianship is made by petition, not by collector, what details must it state so far as can be ascertained? Answer is a comprehensive list of particulars including the minor's identity, residence, property, relatives, existing guardianship, the purpose of the application and qualifications of proposed guardian. Next, which of the following details about the minor must be included in guardianship petition if applicable? If the minor is a female, whether she is married, and if so, the name and age of her husband. Again, what specific information regarding existing guardianships must be stated in the petition? Answer is whether a guardian has been appointed by anyone entitled by the minor's personal law or if any prior application of guardianship has been made. आगे है जी on if the application is to appoint a guardian, what specific information about the proposed guardian must be included in the petition? आंसर इसका their qualification to act as guardian. आगे है जी if the application is to declare a person to be a guardian, what specific information must be included in the petition? आंसर इसका the grounds on which that person claimed to be the guardian. Next, according to section 10 subclass 2, if the application for guardianship is made by the collector, what form should it take? Answer is a letter addressed to the court forwarded by post or other convenient means, stating the particulars mentioned in subsection 1 as far as possible. Next, what additional document must accompany the guardianship application according to section 10 subclass 3? A declaration of the proposed guardian's willingness to act signed by them and attested by at least 2 witnesses. Next, according to section 11 subclass 1, what is the first step the court takes if it is satisfied that there is a ground for proceeding on a guardianship application? Answer is it fixes a day for the hearing of the application and issues notices. Again, in what manner should the notice of the application and the hearing date be served on the specified individual according to section 11 subclass 1 subclass A? आगे है जी आंसर है जी in the manner directed in the Code of Civil Procedure 1908. Again, on whom are the notices of the guardianship application and hearing dates required to be served under section 11 subclass 1 subclass A? The parents of the minor if residing in Pakistan, the person having custody of the minor or their property, the proposed guardian, unless they are the applicant, and any other person the court deems should receive special notice. Again, besides serving notice on specific individuals, how else must the notice of the application and hearing date be publicized according to section 11 subclass 1 subclass B? By posting it conspicuously at the courthouse and the minor's residence and through other means as the court deems fit subject to high court rules. Again, according to section 11 subclass 2, under what condition may the provincial government require the court to serve a notice on the collector? Answer is when any part of the minor's property described in the application is land that a court of arts could supervise. Again, if the provincial government issue an order under section 11 subclass 2 on which the collector must the notice be served on the collector of the district where the minor ordinarily reside and on every collector in whose district any portion of the land is situated. आगे है जी what authority does the collector have regarding the publication of the notice served on them under section 11 subclass 2? Answer is the collector may publish the notice in any manner they deem fit. आगे according to section 11 subclass 3, what charges are associated with the service or publication of notices under subsection 2? No charge shall be made by the court or the collector for such service or publication. आगे according to section 12 subclass 1, what power does the court have regarding the production of a minor? Answer is the power to direct the person having custody of the minor to produce them at a specified place, time, and before a designated person. Again, what kind of orders can the court make for the temporary well-being of the minor according to section 12 subclass 1? Answer B. Orders for the temporary custody and protection of the person or property of the minor as it deems proper. Next, according to section 12 subclass 2, if the minor is a female who ought not to appear in public, how should the direction for her protection be carried out? Answer is the direction for her protection shall require her to be produced in accordance with the customs and manners of the country. Again, according to section 12 subclass 3 subclass A, under what condition can the court not place a female minor in the temporary custody of a person claiming to be her husband unless she is already in his custody with the consent of her parents, if any? Again, according to section 12 subclass 3 subclass B, what is prohibited for a person entrusted with the temporary custody and protection of minor's property? Answer is to dispossess any person in possession of any of the property otherwise than by due course of law. आगे है जी what is the primary purpose of interlocutory orders that the court is empowered to make under section 12 to ensure the immediate safety and well-being of the minor and their property pending the final decision on guardianship. Next is the can the court under section 12 subclass 1 order a relative who does not have physical custody of the minor to produce them in court. No, the order can only be directed to the person currently having physical custody. Next is what is the significance of the phrase due course of law in section 12 subclass 3 subclass B. It means that any dispossession of property must be carried out through proper legal proceeding and not by force or other extra legal methods. Again, according to section 13, when should the court hear evidence related to a guardianship application? On the day fixed for the hearing or as soon as afterwards as possible. What type of evidence should the court hear under section 13? Answer is such evidence as may be presented in support of or in opposition to the application. Next, according to section 14 subclass 1, what action must a court take if it becomes aware the guardianship proceedings for the same minor are also being conducted in another court? Answer is it should stay the proceedings before itself. Next is according to section 14 subclass 2, what procedure should be followed if the courts involved in simultaneous guardianship proceedings are all subordinate to the same high court? Answer is that they shall report the case to the high court and the high court will determine which court will handle the proceeding. Again, according to section 14 subclass 3, what procedure should be followed in cases of state simultaneous proceeding where the courts are not all subordinate to the same high court? इसका आंसर जो है वो आप बताएं, क्योंकि अब मैं सारे ऑप्शंस पढ़ूंगी तो फिर बता पाऊंगी तो वो टाइम लग जाएगा। क्वेश्चन है ये 14 सब क्लास 3 का कि इसमें क्या चीज इंक्लूडेड नहीं है। 6 है जी, सॉरी नेक्स्ट है व्हाट इज, इसकी तरतीब थोड़ी चेंज है क्योंकि वो मैंने मुख्तलिफ औकात में इसके बनाए हैं, तो वो नंबरिंग जो है वो सीक्वेंस बरकरार नहीं रह सके और दोबारा टाइम नहीं मुझे मिला कि उसको मैं एक ही सीक्वेंस में लेकर आऊँ, तो इसको इग्नोर कीजिएगा नंबरिंग को, बाकी क्वेश्चन पे फोकस करते हैं। व्हाट इज द प्राइमरी ऑब्जेक्टिव ऑफ प्रोविजंस इन सेक्शन 14 regarding simultaneous proceeding? To ensure that only one court has jurisdiction over the guardianship of minor at any given time, avoiding conflict orders. Again, who is responsible for informing a court about simultaneous guardianship proceedings in another court according to section 14 subclass 1? Each of the courts involved upon becoming aware of the other proceeding must take action. Again, in a situation where two district courts under different provincial high courts are seized of the same guardianship matter, which authority will ultimately decide which court should proceed? आगे है जी द आंसर है इसका द रिस्पेक्टिव प्रोविंशियल गवर्नमेंट। नेक्स्ट अकॉर्डिंग टू सेक्शन 15 सब क्लास 1, अंडर व्हाट कंडीशन कैन द कोर्ट अपॉइंट और डिक्लेयर टू और मोर जॉइंट गार्डियंस ऑफ अ माइनर पर्सन or property or both? Answer is if the law to which the minor is subject permits such joint guardianships and the court deems it fit. Next, according to section 15 subclass 3, what kind of guardians can the court appoint or declare for a minor? Answer is the B, separate guardians for a person and for the property of a minor. Again, according to section 15 subclass 4, what authority does the court have if a minor possesses several properties? The court may, if it thinks fit, appoint or declare a separate guardian for any one or more of the properties. आगे है जी according to section 16, what happens when a court appoints or declares a guardian for property located outside its local jurisdiction? The court having jurisdiction where the property is situated shall, upon production of a certified copy of the order, accept the appointed guardian and give effect to the order. Next है जी what document needs to be presented to the court having jurisdiction over the property situated beyond the appointing court's limit? A certified copy of the order appointing or declaring the guardian. Next, what is the obligation of court where the minor's property is located but outside the appointing court's jurisdiction upon receiving the certified order? Answer is it shall accept the guardian as duly appointed or declared and give effect to the order. It can only be सॉरी ये दोनों लगे, मैं आप इनमें से चेक कर लीजिएगा काइंडली कि कौन सा ठीक है। अच्छा जी आगे चलते हैं। द एबिलिटी ऑफ अ माइनर टू हैव टू और मोर जॉइंट, वैसे सी ठीक होगा कि वो गलती से आगे चला गया। The liability of a minor to have two or more joint guardians is contingent upon what factor according to section 15 subclass 1. Answer is whether the law to which the minor is subject permits it. Next, Ajib, what is the underlying principle behind section 16 regarding the appointment of guardians of property outside the court jurisdiction? Answer is to ensure that the guardianship orders are effective even when property is located in a different jurisdiction, promoting efficiency and avoiding the need of multiple applications. अगला है जी according to section 17 subclass 1 what is the paramount consideration for the court when appointing or declaring a guardian of a minor? Answer is what appears in the circumstances to be for the welfare of the minor consistent with the law to which the minor is subject. Again, according to section 17 subclass 2, which of the following factor must the court have regard to when considering the welfare of the minor? The age, sex, and religion of the minor, the character and capacity of the proposed guardian, and their nearness of kin, the wishes of deceased parent, and any existing or previous relations of the proposed guardian with the minor or their property. Again, according to section 17 subclass 3, what discretion does the court have regarding the preference expressed by the minor? Answer is if the minor is old enough to form an intelligent preference, the court may consider that preference. Next, according to section 17 subclass 4, what is the limitation on the court's power to appoint or declare guardian? Answer is C. The court shall not appoint or declare any person to be a guardian against their will. Again, in determining the welfare of the minor, the court must act consistently with the law to which the minor is subject. The character and the capacity of the proposed guardian, as mentioned in section 17 subclass 2, would likely involve assessing the proposed guardian's personality, moral standing, ability to care for the minor, and overall suitability for the role. Next, the wishes of if any of the deceased parent are a factor of the court should consider what weight should these wishes be given. They are just one of the factors the court should consider in determining the welfares. ये आंसर जो है वो रॉन्ग है क्योंकि डिसीज्ड पेरेंट की जो विशेस है ना वो फिर विल में आ जाती है और विल जो है वो बहुत इंपॉर्टेंट होती है तो आंसर इसका डी है दे आर मोस्ट इंपॉर्टेंट फैक्टर इन द कोर्ट्स डिस्क्रिशन इसको मजीद एक दफा वेरीफाई कर दीजिएगा लेकिन मेरे ख्याल से डी है इसका आंसर ये बी गलत लगा अच्छा जी आगे चलते हैं ह्यूमन एरर जो है वो एक्सेप्टेबल होते हैं गलती हर किसी से हो सकती है तो ये एमसीक्यूज में खास तौर पर इस तरह की माइनर मिस्टेक्स आपको मिल जाएंगी क्योंकि आंसर जो है वो ऑप्शंस मिलते जुलते होते हैं तो फिर वो एरर आ सकता है बहरहाल what happens if a person proposed as a guardian explicitly states that they do not to be appointed? The court must respect their wishes and cannot appoint them. Next, according to section 18, what is the effect of a court order appointing or declaring a court collector in virtue of their office as a guardian? Any subsequent person holding that office shall also be authorized and required to act as a guardian. Again, when a collector is appointed as guardian by virtue of their office, who is legally obligated to act as the guardian? The person currently holding that particular collector's office. According to section 19, under what circumstances is the court not authorized to appoint or declare a guardian of the property of a minor if the minor's property is under the superintendence of the court of wards? Again, according to section 19A, 19 subclause A, when is the court not authorized to appoint or declare a guardian of the person or if of a minor if the minor is a married female and her husband is in the opinion of the court fit to be her guardian? Next, according to section 19 subclass B, when is the court not authorized to appoint or declare a guardian of the person of a minor? Answer is if the minor's father is living and is not in the opinion of the court unfit to be the guardian of the minor's person. Next, according to section 19 subclass C, when is the court not authorized to appoint or declare a guardian of the person of a minor if the minor's property is under the superintendence of the court of wards competent to appoint a guardian of the person of the minor? Next, what is the key factor the court must consider regarding the husband of a married female minor when deciding whether to appoint another guardian for her person? Next, the answer is the court's opinion on whether the husband is unfit to be her guardian. Next question is what is the underlying principle behind section 19 in restricting the court's power to appoint guardians in certain cases? Answer is to respect existing legal frameworks and familiar relationships where family relationships where a natural or competent guardian already exists or where another competent authority is already involved. Again, according to section 20 subclass 1, what type of relationship exists between a guardian and their ward? A fiduciary relationship. Next, according to section 20 subclass 1, what is the restriction on a guardian's conduct in relation to their office? Answer is that they must not make any profit out of their office except as provided by the instrument of their appointment or by this act. Next, according to section 20 subclass 2, what does the fiduciary relation of guardian extend? Answer is to purchases by the guardian of the ward's property and by the ward of the guardian's property immediately or soon after the ward attains majority, and generally all transactions while the guardian's influence lasts or is recent. Next, according to section 21, what is the general rule regarding a minor acting as a guardian? A minor is incompetent to act as guardian of any minor with specific exceptions. Next, according to section 21, what are the exceptions to the rule that a minor is incompetent to act as a guardian? Their own wife or child. Next, according to section 21, what is another exception to the rule regarding minors' incompetence to act as a guardian in the context of Hindu undivided family? Where they are managing member of an undivided Hindu family, they can be the guardian of the wife or the child of another minor member of that family. Again, the restriction on a guardian making profit from their office is primarily intended to ensure that the guardian acts solely in the best interest of the ward and does not exploit their position for personal gain. Next, the extension of the fiduciary duty even after the ward attains majority, as described in section 20 subclass 2, is meant to protect the former ward from potential exploitation or undue influence by their former guardian during the period when the guardian's influence might still be significant. Again, according to section 22 subclass 1, is a guardian appointed or declared by the court automatically entitled to an allowance? Answer is C. No, they shall be entitled to such allowance if any as the court thinks fit. Again, what is the allowance mentioned in section 22 subclass 1 intended to compensate the guardian for their care and pains in the execution of their duties as guardian. Next, according to section 22 subclass 2, what happens when an officer of government is appointed or declared guardian in their official capacity? Answer is C. Such fees as the provincial government directs shall be paid to the government out of the property of the ward. Next, who determines the amount of fees to be paid to the government when the government officer acts as guardian in their official capacity? The provincial government by general or special order. Again, from where are the fees paid to the government when a government officer acts as guardian in their official capacity? Answer is C. Out of the property of ward. Again, the court's discretion in granting an allowance to a non-government guardian suggests that the allowance may vary depending on the factors such as the extent of the guardian's responsibilities and the value of the ward's estate. Next, the provision of for fees to be paid to the government when its officer acts as guardian likely serves to फिर नहीं लगा हुआ इसका आंसर, इसको चेक कर लीजिएगा। ये है द प्रोविजन ऑफ फीस के हवाले से जो है वो कंपनसेशन या फिर क्या दिया जाएगा, इसको चेक कर लीजिएगा प्लीज। एंड द फ्रेज केयर एंड पेन्स इन द एग्जीक्यूशन ऑफ हिज ड्यूटीज इन सेक्शन 22 सब क्लास 1 encompasses the overall effort, responsibility and time dedicated to the guardian to fulfill their obligation towards the ward. Next, according to section 23, if a court is collector is appointed or declared by the court as guardian of a minor, or to whose control are they subject in all matters related to the guardianship? The control of the provincial government or an authority appointed by that government through official notification. Next, how does the provincial government designate the authority that will control a collector acting as a guardian? आंसर है इसका बाय नोटिफिकेशन इन द ऑफिशियल गजट। आगे है जी ऑल नेक्स्ट है द कंट्रोल मेंशन्ड इन सेक्शन 23 extend to all matters connected with the guardianship of the ward, both persons and property. Next, what is the primary purpose of subjecting the collector when acting as guardian to the control of the provincial government or its appointed authority? To ensure that the collector's actions are aligned with government policies and are properly supervised. आगे है जी can the court that can appointed the collector as guardian directly issues orders to the collector regarding the guardianship matters? No, in all guardianship matters the collector is subject to the control of the provincial government or its appointee. आगे है जी the authority appointed by the provincial government to control the collector as guardian could be a committee of legal experts. Next, the mechanism of control through a provincial government or its appointed authority ensures a degree of uniformity and accountability in how collectors perform their guardianship duties. आगे है जी the phrase all matters connected with the guardianship of wards is broad and likely includes decisions related to minors' education, health, and upbringing, the management, preservation, and disposal of the minor's property, legal proceeding on behalf of the minor, all of the above. Next, according to section 24, what is the primary responsibility of guardian of the person of ward? Answer is ensuring the ward's legal rights are protected. Besides custody, what other essential aspects of the ward's well-being must a guardian of the person look after according to section 24? Answer is the ward's sport, health and education. Next is the duties of a guardian of the person also extend to such other matters as the law to which the ward is subject requires. What does this imply? Answer is the guardian's responsibility may be further defined by the minor's personal law or religious customs. Next is the duty to look to the support of the ward primarily involves providing emotional encouragement and moral guidance. Again, the duty to look to the health of the ward primarily involves making decisions about the ward's medical care and well-being. Again, making decisions about the ward's schooling and academic development. Next, the scope of responsibilities for a guardian of the person as outlined in section 24 indicates that their role is primarily focused on the ward's physical, emotional, and intellectual development and well-being. Next, the phrase custody of the ward implies that the guardian of the person has the responsibility of the ward's day-to-day care, control, and residence. Again, according to section 25, subclass 1, under what condition can the court order a ward to return the custody of their guardian of the person if the ward has left or been removed? Answer: if the court is of the opinion that it will be for the welfare of the ward to return to the guardian's custody. Next, according to section 25, subclass 1, how can the court enforce an order for the return of the ward to their guardian's custody? Answer is by causing the ward to be arrested and delivered into the custody of the guardian. Again, according to section 25, subclass 2, what power can the court exercise for the purpose of arresting a ward who is to be returned to their guardian? The power conferred on a magistrate of the first class by section 100 of the Code of Criminal Procedure 1898. Next is section 100 of the Code of Criminal Procedure 1898 referred to in section 25 subclass 2 in this act typically deals with the power to issue search warrants for persons wrongfully confined. Again, according to section 25 subclass 3, what is the effect of a ward residing against the will of their guardian with the person who is not their guardian? Answer is it does not of itself terminate the guardianship. Again, the primary consideration for the court when ordering the return of a ward to their guardian under section 25 subclass 1 is the welfare of the ward. The provision allowing the court to order the arrest of a ward highlights the legal recognition of the guardian's right to the custody of the ward when deemed in ward's welfare. Next is the welfare. The fact that a ward residing against the guardian's will with another person does not automatically terminate the guardianship suggests that The legal relationship of guardian continues until a formal order of termination is issued by the court. Again, according to section 26 of clause 1, which guardians of a person appointed or declared by the court generally require the court's permission to remove the ward from the jurisdiction. Answer is guardians appointed by the court unless they are the collector or appointed by will or other instrument. Next is according to section 26 of clause 1 are the what are the exceptions to the requirement of obtaining the court's leave to remove the ward from its jurisdiction. Answer is if the guardian is the collector or was appointed by will or other instrument. According to section 26 of clause 1, removal of the ward from the court's jurisdiction without leave is permitted for medical emergencies requiring treatment outside the jurisdiction. Next, according to section 26 of clause 2, what kind of leave can the court grant for the removal of ward from its jurisdiction? Answer is C, either special or general leave as defined by the court's order. Next, the requirement for court leave to remove a ward from jurisdiction is primarily intended to ensure the court retains oversight of the ward's well-being and the guardian's action. Next, a guardian appointed by a will generally does not need the court's leave to remove the ward from jurisdiction. This suggests that testamentary guardians are considered to have greater autonomy. Again, the term prescribed in section 26 of clause 1 likely refer to purposes specified in rules made by the High Court and under this Act. Next, if a guardian removes a ward from court's jurisdiction without obtaining the necessary leave, what potential consequences might they face? Automatic termination of guardianship, being held in contempt of court, being required to return of the ward jurisdiction, and potentially facing the penalties. All of the above, right answer. According to section 27, what standard of care is a guardian of ward's property expected to exercise? The care that man of ordinary prudence would exercise if the property were his own. Next, according to section 27, what types of actions is a guardian of a property authorized to take? All acts which are reasonable and proper for the realization, protection, or benefit of the property subject to the provision of this chapter. Again, the phrase realization of the property in section 27 likely refers to understanding the true value and potential of the property. Next, the phrase protection of the property in section 27 likely refers to taking necessary steps to safeguard the property from damage, loss, or encroachment. Next is the phrase benefit of the property in section 27 likely refer to managing the property in a way that maximizes its value or generates income for the ward. Next, the guardian's power to act for the ward's property is subject to the provision of this chapter. This means the guardian's action must comply with the specific rules and limitations outlined in the relevant sections of the Guardian and Ward Act 1890. The standard of care expected of a property guardian under section 27 emphasize acting with the diligence and prudence that a reasonable person exercise with their own affairs. Next, which of the following actions would likely be considered as reasonable and proper act for the benefit of the property under section 27? Selling a dilapidated property and reinvesting the proceeds in a more stable asset with the court approval if required by other provisions. Next, according to section 28, what is the general rule regarding a guardian appointed by will or other instruments power to deal with the ward's movable property? Their power is subject to any restriction imposed by the instrument of their appointment. Again, according to section 28, what types of transaction involving the ward's immovable property are specifically mentioned as being subject to restrictions in the appointing instrument? Answer is mortgage, charge, transfer by sale, gift, exchange, or otherwise. Again, according to section 28, under what circumstances can a testamentary guardian dispose of immovable property belonging to their ward in a manner that overrides restrictions in appointing instrument? Answer is if they have been declared guardian under this act by a court and that court permits disposal by written order notwithstanding the restriction. Next, what is a prerequisite for a testamentary guardian to obtain a court order permitting them to dispose of immovable property contrary to the restrictions in their appointing instrument. They must have been declared guardian under this act by the court. Again, the court order permitting a testamentary guardian to dispose of immovable property. This by restriction must be a written order specifically allowing the disposal of the identified property in a permitted manner. Again, the provision in Section 28 suggests a balance between the autonomy granted by a testamentary appointment and need for the court oversight to protect the ward's interest. Next, if a testamentary guardian who has not been declared guardian by the court wants to mortgage their ward's property, they must adhere strictly to any restrictions outlined in the will or other instrument. Next, the phrase notwithstanding the restriction in Section 28 emphasizes that the court's written order has power to completely disregard the restriction in the appointing instrument under specific circumstances. Again, according to Section 29, which guardians of property appointed declared by the court require the court's previous permission to mortgage, charge, or transfer the ward's immovable property. Guardians appointed or declared by the court who are not the collector or appointed by will or other instrument. Next, according to Section 29, subclass A, what actions regarding the ward's immovable property require the previous permission of the court for a guardian other than the collector as a testamentary guardian, mortgage, charge, or transfer by sale, gift, exchange, or otherwise. According to Section 29B, what limitations apply of the leasing of ward's immovable property by a guardian other than the collector or testamentary guardian without court's previous permission? Lease exceeding 5 years or any term extending more than 1 year beyond the date of the ward attaining majority. Next, according to Section 30, what is the status of disposal of immovable property by a guardian that contravenes the Section 28 or Section 29? It is voidable at the instance of any other person affected thereby. Again, who has the right to challenge a disposal of immovable property made by a guardian in contravention of Section 28 or 29? Any other person affected by the unauthorized disposal. Next is the requirement of for court permission under Section 29 aims to protect the minor's valuable immovable property for mismanagement or unauthorized disposal by certain types of guardians. Again, the concept of a transfer being viable under Section 30 means that the transfer is valid unless and until it is challenged and set aside by person with the right to do so. So the next, a guardian appointed by will wants to sell their ward's property and the will imposes no restriction on such sales. Do they need permission under Section 29? Yes, all guardians must obtain court permission to sell immovable property. नेक्स्ट जो है वो 31 है, 30 तक हो गया कंप्लीट. नेक्स्ट इंशाल्लाह 31 से ऑनवर्ड और हाई कोर्ट ऑर्डर रूल्स एंड वॉल्यूम जो चैप्टर वॉल्यूम 2 चैप्टर 2 है गार्डियन एंड वार्ड से रिलेटेड उसके एमसीक्यूज भी साथ नेक्स्ट वीडियो में आपको मिल जाएंगे इंशाल्लाह. थैंक यू सो मच फॉर लिसनिंग. अल्लाह हाफिज.